I know her because I was one of the judges.
You're Louisa Magruder?
Yes, ma'am.
And Ms. Magruder is currently on probation for sexual assault of a child in cause number 1625158. Motion to revoke probation has been, or motion to revoke unadjudicated probation has been filed. And Mr. Bynum, do you have an announcement?
Yeah, if we could confer with the court perhaps about if we, I mean, we're ready to clean out Drew and all of that, but I've been speaking with, this is my first time appearing on it.
Sure.
Ms. Magruder, if I can just introduce myself and why I'm here. And little known fact about Ms. Magruder is that she's actually one of the class plaintiffs in what is still the largest civil rights case related to bail in the history of the country in federal court here in the Southern District. So she sued Harris County, the judges, regarding the misdemeanor bail practices. And I know her because I was one of the judges she sued. And but I agreed with her. Which, as a criminal lawyer, I don't have much of a conflicts practice. But
hold on. Did you catch that? The defense attorney casually drops that he was one of the judges she sued. That's not just courtroom drama. That's legal irony at its finest. She was a named plaintiff in a massive federal civil rights lawsuit over bail practices in Harris County. We're talking about litigation that challenged whether people were being jailed simply because they couldn't afford bond. That's constitutional law territory, due process and equal protection under the 14th Amendment. And now she's back in criminal court, fighting to stay on probation for a second-degree felony. Talk about full circle. The question is, does her history as a civil rights plaintiff help her credibility or hurt it?
This was a pretty funny one. The lawyers in that case called me and asked me to try to take care of her here. And what I say about being on an MAJ is that I'm the last to the party. You know, that everyone here has been here on the case for much longer than me. It seems to me that she's 8 years into a 2-year probation and has put down many years of sobriety in there. She's responded successfully to ISF in 2020.
Let me stop you, because I guess just as far as kind of procedurally, if there is, the way I'll handle all of the motion to revoke. So if there's an agreement, y'all can get that taken care of, do paperwork for whatever's going to happen. If there's not an agreement and you want to argue for me to do certain things,
Right.
Then what I'd rather do is go through the motion, get pleas of true or not true, and then what I do is reset the case for a sentencing hearing. So everybody has time to provide whatever information they want, bring any witnesses they want. Probation will do an updated pre-sentence report that'll give me more information, and then I'll listen to all of that on that day.
Okay.
Okay.
I understand. Could I just add where I was going with what I was saying? And I'm sorry, I'm long-winded. I was wondering if the court would consider. She has a TRAS from last May that recommends substance abuse treatment. I was wondering if the court would consider, with the consent of the state, amending to safety.
So what would happen is I would still get an updated report, because I need to see what all if they agree to that, then yes, I will consider it. So if y'all have an agreed recommendation, yeah, she cannot go because of I didn't think her underlying offense. She's not eligible.
Judge, just to let the court know, I don't want to interrupt.
No, please.
And the court knows the history with this, but
Yeah.
back in June of 24, we did where the court was absolutely will not accept the plea agreement on this.
Okay.
We're not gonna agree to anything because we've done this.
We've been here before. It's unfortunate that I recognized Miss Magruder over the last few years, and so apparently I have.
We've given twice. We've actually given it.
Okay, so
compliance, very strict compliance.
all right. So here's what we need to do then, based on that, just so that we can all get.
And there it is, the tone shift. When a judge emphasizes very strict compliance, that's courtroom code for, we've been patient before. This isn't just about missing a meeting. This is a motion to revoke on deferred adjudication probation. That's serious. If probation is revoked here, the judge isn't limited to a small sanction. she could sentence all the way up to the statutory range for a second-degree felony. In Texas, that can mean 2 to 20 years in prison. And notice something else. The state flat out refuses to agree to any deal. That tells you negotiations have already broken down behind the scenes. So now the strategy shifts. This becomes a sentencing hearing battle. Mitigation versus accountability. Rehabilitation versus punishment. What do you think? 8 years into probation. Does that earn some grace, or does repeated noncompliance cancel out?
Caught up is get the pleas of true or not true to the allegations, and then reset it for a hearing. You can provide whatever you need, argue whatever you want, bring whatever witnesses. State can do the same. We'll get that updated report, and then I'll make a decision what to do. Okay?
Well, I'll enter pleas and not true.
So let's do this then. Ms. Magruder, please raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. And will your client waive the formal reading of the motion?
Yes, we will.
Okay. Let me get this pulled up. So, Ms. Magruder, in cause number 16-25158, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation January 29th of 2018 for sexual assault of a child, a second-degree felony, and that was a 10-year deferred probation. Is that correct? And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department on May 23rd of 2025 and to the administrative hearing on June 2nd of 2025. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 alleges that you failed to submit to alcohol and/or drug screening on June 2nd, May 28th, and May 19th of 2025. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of June 2nd, 2025 in the amount of $8,645. Is that true or not true? And then count 5 alleges that you failed to enter and successfully complete the Jefferson County Drug Intervention Program, JCDI, and that's from the order from September 24th of 2024. Is that true or not true? All right, so I will have pleas of not true entered for all 5 counts. Again, we'll reset the case for sentencing, and I will ask for an updated pre-sentence report.
Not true to all 5 counts. That's a bold move and a calculated one. By pleading not true, she forces the state to prove the violations at a hearing. This buys time. It allows the defense to gather mitigation evidence, treatment records, employment verification, maybe testimony about sobriety efforts. And remember, probation revocation hearings don't require proof beyond a reasonable doubt. The burden is lower, a preponderance of the evidence, more likely than not. So the uphill climb is real. Now it all comes down to that updated pre-sentence report. Judges lean heavily on those. It's the difference between continued supervision or incarceration. The next hearing, that's where the real stakes hit. Stick around, because when probation hangs by a thread, every detail matters.
Obviously, anything that you think is important for me to know, get that information to Mr. Bynum. He'll present it to me on your behalf on that date. All right, we'll see you back on that date. Thank you.